Good afternoon, everyone. My name is Lluc Cerda. I'm a senior associate here at Samfiru, Tumarkin. I'm based in Calgary, but today I'm in Toronto at our head office here in Toronto. I'm preparing for an appeal at the Court of Appeal this coming week, and so I flew down for that. Thanks for joining us today. We're here to answer any questions you have about your employment rights. We'll be here for the next half hour. So feel free to put your questions in the chat, and I'll get to as many of them as I can. I recommend that you put them in as early as possible rather than wait right at the end. I always tend to get a flurry of questions right as I'm signing off. So if you want to avoid having to come again tomorrow for our next show to get your answer question, put them in early. So one thing I wanted to talk to you about, some of you may have heard, we've been in the news this week. The firm has started a class action lawsuit against Spotify. Spotify is, of course, the Canadian retail giant, similar to Amazon. So unfortunately, there was a round of layoffs in May at Spotify. And as you probably are aware, when you are laid off or permanently laid off or terminated, you're owed a severance package. And so Spotify offered some severance packages to their employees. And these employees accepted the severance packages that they were provided. And now Spotify seems to be saying, well, hold on a sec, we made a mistake in the offer we made you. We're not going to pay you what we both agreed you were going to get when we signed these settlement documents. We're going to pay you something less, something different. All right. And it doesn't seem to have just happened to one employee. It seems to have happened to multiple employees. Now, this touches on something that I often get questions about. People are like, you know what? I don't trust my employer as far as I can throw him or her. Why would I agree to put an end to my lawsuit now for a severance package that they now agree they're going to pay me? But there's no guarantee. When am I going to see this money? Well, listen, this is the thing. Once you sign a settlement agreement, and that's a contract, and it can be enforced, and that's precisely what, if Spotify is found to have done what we're alleging, that's precisely what these settlement agreements will be for, to be enforced. Basically, it's arguments saying, well, we made a mistake over 2,000 employees. We shouldn't have paid them we shouldn't have offered what we wanted, what we did. I don't know if that's really going to hold a lot of water in court. We'll see how the case progresses, but right now I'm not very hopeful for Spotify's chances. And so I tell them the same thing to my clients. I tell them, listen, if you sign on the dotted line and they do too, that's a deal. That's an enforceable deal. It means, if they don't pay, we have to go back to court. That's never fun, but it's not impossible. All right. So, oh my God, it seems I've been saying Spotify. Sorry about that. I'm a huge fan of Spotify. I love Spotify. I didn't mean Spotify. I meant Shopify. I hope you guys picked up on that. Thank you, Dan, my man in the booth, for letting me know. My apologies to Shopify. I retract everything I said about to Spotify. Rather, I retract everything I said. I'm very confused here. Sorry about that. Don't know whether Spotify did anything wrong. I was addressing my comments to Shopify. All right. So all that to say, if you were laid off during the Shopify round of layoffs and you too are having trouble getting what you agreed to in terms of your severance, get in touch with us. We have more information at stlawyer.ca. We have a Shopify severance class action lawsuit. Google that. It should come up pretty quickly. And you can get more information on the lawsuit and how you sign up. All right. Well, I was making those mistakes between Shopify and Spotify. We got a few questions come in, so let me move to those. We have a question from you two, from D. Marilyn. I'm still in my probation period, and my employer is talking about changing my position from a managerial job to an administrative one with reduced pay. What advice would you have for me? So that would be a constructive dismissal in most cases, right? Being demoted from a manager to an admin position with a reduction in pay, that would be a constructive dismissal. What happens, though, when you're constructively dismissed, your choices are, well, what are my choices now? Well, I can quit and go after my severance. The problem when you're on probation is you're usually not entitled to severance if there's a probationary clause in your employment contract. So it could be that, yeah, you have the right theoretically to quit and go after your severance, but your severance entitlements might be so low that it doesn't really equate to much. So that's a little bit of an issue. You might want to have to think about, just basically whether you want to stay in this role this new role or whether you want to leave. They can't force you to accept it for sure. But even if you tell them no, you'll have to terminate me. What are you owed if you're within your probationary period? So that's kind of the unfortunate answer to that. You don't have a lot of right to severance when you're in your probation period. We have another question coming in from Don Nguyen. I've been working as a software developer for 22 years. The application that I'm developing is not generating revenue as much as before, is not generating as much revenue as before. My employer wants to move me to a different role. The role is either quality assurance or development of another application that I have no knowledge of the technology. Can I be refused to be moved to a different position? What is your advice on this? All right. So again, what we're talking about here, Don, is have you been constructively dismissed? So to be constructively dismissed, there has to be a substantial change to your employment conditions or agreement, and that has to lead a reasonable person to believe that the employer doesn't want to continue to employ you in your role. All right. So it's a very legalese kind of answer, but essentially what we have to ask ourselves is there a role for you in your quality, in your previous role, developing the application? And if there isn't a role for you, and it doesn't seem to be, is the new position so substantially different from the old one that it's a substantial change to your working conditions? So it kind of depends on if you've only been working on this kind of application the whole time you've been there, and they're asking you to transition into learning new software or transitioning into a non-programming role, because quality assurance seems to be like a non-programming role. I think there is an argument for sure that that's a different position. That's a different role. Now, there might not be any reduction in compensation or change in compensation, but there doesn't necessarily have to be a change in compensation for there to be a constructive dismissal. So basically, the tricky part is you have to really look at all the facts, and I'm not sure I got all the facts from you today. Probably if I had you on the phone today, Don, I'd be asking you a lot of questions about, well, exactly how is it different? How is it the same? The role, will you be in a different work location, on a different team? Are you going to be reporting to someone new? There's a lot of issues that you can take into consideration. Is your commute you're going to have to go commute further away? Is your compensation going to change? You didn't address that. It might change, in all elements of your compensation, not just your annual salary. What about, stock options, bonuses, things like that? All of that whole kind of thing needs to be looked at to determine whether that amounts to a constructive dismissal. But you have the start of it in the sense that they're changing your position little by little, and then pretty soon you're going to be completely out of caring for an application or a program that is not generating enough revenue. So there's definitely something there. We just need to explore it a little bit more. Might want to get in touch with me so we can discuss a little bit further. But if it does amount to constructive dismissal, then your choices now are to say, well, I don't want these other roles. Don't give them to me. If you have nothing left for me, if you don't have a job for me, then terminate me and pay me my severance package. So the first question you got to ask yourself is, would you rather leave and try your luck somewhere else with a severance package, or would you rather try these new roles that they're offering you? That's the first question only you can answer. I can't answer that for you. So that's the first question you have to do. Now we have another question coming in from Darcy on Facebook. Can an employer make you sign a new contract having worked there for 12 years already? So an employer cannot force you to sign, and I see this almost every week, if not close to every day. Someone comes to me and saying, I've been terminated. I've been working somewhere, as Darcy has, for 12 years. 3 months ago, they made me sign a new employment contract. And that employment contract, lo and behold, has a termination clause in it. And that termination clause is in there to reduce the severance that, someone like Darcy might be owed. So where Darcy might be owed, 12 months of severance if they're terminated, Darcy signed the contracts and now is only owed maybe 8 weeks of severance, right? So it's gone down substantially. And severance can be as much as 24 months of severance, 2 years of severance. That's a lot of money to go from 24 months to 8 weeks, 2 months, And that's generally why they show you, an employer asks you to sign a new employment contract. You read these employment contracts, anyone can see they're not written for the employee's benefit. They're really written for the employer's benefit. And people sign them, and they tell me, I ask them, why did you sign this contract that takes away all of your employment rights? And they tell me, well, I was afraid that if I didn't sign this contract, I would lose my job. And what I tell everyone is that you have more job security, Darcy. You have more job security not signing that contract than by signing it. Because by signing that contract, your severance entitlements, what they need to pay to terminate you, is probably a year's salary, if not more. Now, if you sign that contract, what they need to pay, the cost of terminating you, has gone down sixfold. Okay. So, of course, it's easier to terminate you. They're going to terminate you rather than the person who refused to sign, who's also with substantial severance. So, no, you don't have to sign those employment agreements, right? And they'll say, well, listen, here's $250 to sign. So, Darcy, let's suppose you make $60,000 a year, and you're owed a year's worth of severance at $60,000, but you signed the contract. You're only owed 8 weeks now. So all of a sudden, your $60,000 severance has gone down to $10,000, all in exchange for a signing bonus of $250. So I just don't see that being worthwhile, right? And basically, if they say, well, you're going to be terminated if you don't sign, like I told you, the chance that you get terminated are actually greater if you do sign. So be careful for that. Okay. So we have a question here from Tanya G. Tanya is asking, when unions doesn't help, what steps are taken? So Tanya, we don't really work with unionized staff, so it's not my biggest area of expertise, but I do know that there is a sort of complaint that you can make to the labor board if you feel your union is not representing you very well. And that's make a complaint because the union has a duty of fair representation to you. So you can go to the labor board and say, well, listen, my union is not fairly representing me. Labor board, do something about it. So that's the option you have if you feel that you're not being fairly represented by your union, is to go to the labor board and do a complaint on the duty of fair representation. Not an area of practice not an area of law I really practice in, so I couldn't tell you much more about it than that. But those are your options. Unfortunately, fortunately or unfortunately, when you're with a union, basically the unions are representative. It's very hard to be able to hire your own lawyer. It's not that we don't want to work with you, is that a judge will throw it out of court almost immediately and tell you that you have to go through your union. So it's not that we don't want to help. It's just that's the way the law is written. We have a question coming in from Art Miggs. Art asks, what happens if you don't have a signed employment contract when you're let go? So that's another reason a lot of people sign employment contracts, is they want something in writing. And I can tell you, I tell this to people all the time, is even if you don't have a written employment contract, you have employment rights. All right. Contracts are not the only place that laws are kept in Canada. So there are, of course, everyone knows there's legislation that says, the law is this, right? And there's legislation like that exists independent of any employment contract that applies to each and every worker in Ontario or in Alberta or in Quebec or across Canada, really. Every employee is governed by some sort of employment rights legislation, whether or not they have an employment contract or not. For instance, everyone knows that the minimum wage is a certain amount. In Alberta, it's $15. $15.25 it might be now. Now, that's not because it's written in your employment contract. That's because it's written in the law called the Employment Standards Code. And there's also other laws that apply that have been developed by judges. That's often referred to as the common law. I won't get too technical into it, but it doesn't mean that you don't have any rights if you don't have a written employment contract. In fact, what written employment contracts are trying to do is limit those rights that you do currently have, that everyone who has an unwritten employment contract benefits from. So, if anything, people with written employment contracts oftentimes have less rights than the people who have unwritten employment contracts. So, if you're terminated, you're entitled, and you don't have a written employment agreement, you're entitled to your maximum severance. A lot of time, people get employment contracts that have termination clauses. That the point of the termination clause is to limit what your full severance will be. As I was explaining earlier, your full severance can be up to 24 months of compensation, and that can be reduced to as little as 1 week in some cases. All right, so you want to definitely watch out for employment contracts. Rule of thumb: if you didn't help to write it, it's probably not in your best interest. All right, these contracts are not written with you in mind; they're written with the employer in mind and protecting the employer's best interests. So, although you don't necessarily have to refuse any employment contract you're presented with, it does make sense to have it reviewed. And it does make sense if you're currently employed to say, well, listen, we already have a working relationship. I don't feel I need to change it by signing what you're presenting to me. I'm not going to sign that. I'm happy to continue working on the terms that we had previously, but I'm not going to sign this new employment contract. I don't think it benefits me. And so I'd rather just continue on the way we had before. And now the ball is back in the employer's court. Do they want to terminate you and provide you with the severance that you're owed, or something else? But basically, if they let it slide, then you continue on the terms that you previously had, which is, amongst other things, if you're terminated, you're entitled to your full severance for sure. Now we have an email question from Donna. Donna is asking, can an employer use a workplace write-up from 3 years ago to let you go with cause? I mean, theoretically they could. It's not going to look great in court, okay? I mean, we can't stop an employer from terminating you for cause. What you can do is have a judge review whether they actually had cause to terminate you. And if a judge finds there was no cause to terminate you, then they're going to order that you get your full severance, Donna. All right. So that's where we come in. I do a lot of wrongful dismissal cases, or just cause dismissal cases rather. And I say, you can get a judge to review that. Again, the same rule of thumb applies. About 99% of these cases are settled prior to a trial. So it's not all the cases where an employer has said that they had cause to terminate you that end up at trial. And this one would seem to me a little bit suspicious. So what I'm understanding from what you're saying, Donna, is that you were written up potentially 3 years ago. They wrote you up. Nothing happened for 3 years, and now they want to terminate you, and they say, well, listen, this is what you did 3 years ago, so we're going to terminate you for cause. All right. Big problem with that is then why didn't they terminate you 3 years ago? They wrote you up 3 years ago, so that's a form of discipline. A written warning is a form of discipline. That seemed to be sufficient at the time. You were sufficiently punished according to them, or disciplined rather, for whatever it is that you did wrong. And now they're saying, oh, actually, we're going to discipline you again. So, I mean, we've all heard of double jeopardy in the criminal context, that you can't be convicted twice of the same offense. It kind of applies in just cause terminations as well. They can't punish you twice for doing the same thing, right? Especially if there's a 3-year gap between those two periods, right? If they say, well, listen, what you did was wrong, and we're going to give you a first written warning about it. It's going to go on your employee file. You say, fine, okay, I messed up. I'll take the warning. I've changed my behavior. I've been on stellar behavior for 3 years. All of a sudden, oh, look what we found in your employee file. Now we're going to terminate you for cause. Not a very strong case for the employer, I would say, based on what you've described to me, Donna. So if that's happened to you, reach out to us. We can definitely help on something like that. Absolutely. We have another question coming in from Ashley Burrows. Ashley asks, can you take a temporary position while on layoff from your full-time job? Yes, you can, Ashley. So basically, the only real challenge is that at some point when you are called back to work, you usually have a very short window to come back to work. Usually it's 7 days. So if you don't come back to work at the 7 days because you're working out your notice at your temporary job or something like that, they could say, well, you've abandoned your position. We called you back, you never came back, so could say it's over. So it's kind of hard to establish that you've abandoned your position, but that's essentially what they would try to argue. So what I'm saying is, if you take this temporary rule, try to make sure that you don't have to provide any, kind of notice of resignation in case you get called back, because you want to be able to leave that temporary job as quickly as possible to go back to the job that you were laid off from. You sometimes see employers make the argument, well, listen, you're supposed to work for us full time. We want your full time and attention. Now we laid you off. Now you can't go look for other work. It doesn't work that way. I mean, you are willing to come back when they call you back, but right now they don't have work. Nothing prevents you from going to work somewhere else. All right. So absolutely, I don't see an issue with that at all. We have a question. Oh, Tanya's giving us a thumbs up. Thank you, Tanya. Thanks for tuning in today. All right, we're getting close to the end. So last call for questions. If you have any questions that you want to ask me, feel free to put them on the chat. We also have a lot of information on our website. I forgot to mention it so far today. We are at stlawyers.ca, stlawyer in the singular.ca. We have a lot of information on your employment rights. We have repeats of today's show and all the other shows that we do. We actually have another show coming up later on this week. We try to get as many of these shows out. Generally, we have a show every day. So if I missed your question today, join us again tomorrow when my colleague Madalena is going to be answering your questions about employment law as well. So we have another question coming in from Arlene today. Arlene is asking us, can an employer force you to resign from your job? What if they just stop scheduling you for work? So they often try to force you to resign from your job so that they don't pay you severance. That, if you've been listening to the show today, you've heard the term constructive dismissal. That is a constructive dismissal. If they're trying to force you to resign and you can prove that they're trying to force you to resign, that's a constructive dismissal. So the example you gave is they're no longer scheduling you for hours. All right. So there's potentially a lot of reasons why they wouldn't schedule you for hours. But if you're no longer scheduled for hours, it's like kind of being laid off, right? I mean, you can treat that as a constructive dismissal. It kind of depends. You want to kind of get an idea of why they're not scheduling you for hours and when they expect it'll pick up again. Generally, what they'll tell you is just that it's slow now. But if you know that other people are getting hours and you're not, and they're really trying to do this to push you out, then you can just say, well, listen, this is a constructive dismissal, paying my severance. I'm getting out of here. All right. So basically what you do, you'd say, well, listen, I'm not accepting that you can just not schedule me for a whole week or a whole couple of weeks without any hours. I'm going to treat that as a termination. Pay me my severance. I'm leaving. All right. So that's how you would do that. Thank you, Don, for the heart shape emoji. We appreciate you listening in. That was an interesting question you had. Feel free to reach out. As I said, if you have some more questions about whether the change in your position is a constructive dismissal. All right, here's the last one for us. Question from Caitlin, on YouTube. I have been having some mobility issues. My doctor suggests reducing my work hours. Is this a form of accommodation? Can my employer deny this request? So it's definitely a form of accommodation. In fact, what you see a lot is a lot of people firstly take a full medical leave, a full-time medical leave, and then when they come back from medical leave, they do a gradual return to work. Or maybe for the first couple of weeks, they might work, 3-4 hours a day, and then it slowly goes up over, about 2 to 3 months to a position where they're back to working full-time hours. So it is a form of accommodation. If your doctor is willing to put that in some form of doctor's note that you can only work certain hours during the day or a certain amount of hours in the day, then get that doctor's note, give it to your employer, and now then you and your employer have to work together to see if they can accommodate you to the point of undue hardship. All right. So try to be precise when you get your doctor's note. Are there certain hours that you can't work in the day, for instance, the morning or the evening, or is it you just need to work only a certain amount of hours a day, like 5 hours a day? If you can work anytime during your regular shift, so long as it's only 5 hours, just say that. Makes it easier for the employer to decide how to schedule you. and therefore makes it more likely that they do accommodate you rather than tell you, well, we can't accommodate you, apply for long-term disability, which you probably won't get if it is actually possible for them to accommodate you. So try to get that doctor's note. If the employer generally has questions once they get the doctor's note, well, what is it about working more hours that affects your mobility or stuff like that? You tell them, well, listen, why don't you put that in a letter? I'll take that back to my doctor and have my doctor answer that question. That's a medical question. I'm not a medical doctor. That's the advice I give to people when they make these kinds of requests. Try to, if they have questions about the accommodation, try to have the doctor address it. If they say, well, listen, how about we have you work full-time one day and half-time the other day and alternate like that? Does that work? And that's a question that should also be asked to your doctor, right? Unless you know for sure that that would work or know for sure that that wouldn't work, have it reviewed, have the accommodation plan reviewed by your doctor. You and your doctor decide, does this fit your restrictions? And if it does, then perfect. If it doesn't, then it needs to be tweaked some more. One important thing is that you might say, well, listen, I really want to work morning till 3, for instance. But if it's up to the employer to decide what the accommodation is, so long as it fits your restrictions, that's what the accommodation is. You might have your preferred accommodation. They just need to find an accommodation that meets your restrictions, all right? So it's important that you collaborate with your doctor, that you and your employer when you're asking for an accommodation, and you keep the avenues of communication open. It's always my advice. I've seen people lose their human rights cases because they became intransigent. They said, this is the only accommodation that will work for me, give it to me or else. And the employer's like, well, actually, we have another option we think would work. Why don't you work with us on that one? You have to work with your doctor, always keeping in mind that you shouldn't work outside of your restrictions. So if your restriction is no more than 5 hours a day, and that's what your doctor is saying, then it's not 5.25 hours, it's not 6 hours, no more than 5 hours a day. All right, so keep that in mind. All right, my name once again is Lluc Cerda. I'm a senior associate. I'm here in Toronto this week. Usually I'm in Alberta. I'm the managing associate of our Alberta office. Feel free to tune in tomorrow when we will have another show to discuss your employment rights. It's been a pleasure for all of you to have tuned in. And lastly, I thank you too to Ashley Burrows for sending a quick thank you right at the end. We appreciate that. Thanks for tuning in. Take care.